manggar.
Good afternoon, ladies and gentlemen. Hindi ko sinabing pumunta kayong SM ha. Hindi ko sinabing mamasyal kayo ha.
Yes, sir.
Sir, pauwi pa lang.
Sir, ayos lang. Nakakonect ka Crypto Shop ngayon. Awan video.
Sige.
Sir, ayos lang.
Shot puto.
Ngayon lang.
Thank you, sir.
Kasalanan ng weather to. Kita nyo naman, nagporma-porma rin ako.
Grabe, sir. Grabe, sir. Naglamid. Grabe, dito yung mangyayari dito.
Well, sayang mo, tinakapurporma tayo tapos basahin lang tituloy niya.
Agree,
Okay.
sir. Agree.
So, enough with that. So, let's get serious, ladies and gentlemen.
Yes, sir.
And please note that we are recorded.
Sir, present.
Mr. Lomidio, ilan kayo dyan? Ay,
Sana all group class.
2, 3.
Sir, as admin kami, sir.
5, 6.
oh, kindly write your names on the group chat. Those who are participating as a group. Yung mga nagpa-participate as a group, kindly open cam. Okay, so while waiting for the others, allow me to share my screen. Where have we ended yet last week? Can you see my screen?
Yes, sir.
Yes, sir.
Yes, sir.
By the way, are you prepared with your notes? Have you did your homework?
Sir, back safe.
It will be checked next meeting na lang.
Fine.
Alexander Kafay, kindly check your mic. Naku, naglag. You too, Miss Anna Marie. Kindly send me the list of your names participating as a group.
Sir, nai-send, sir.
Okay, sige. Antayin ko lang yung PowerPoint ko, naghang. Makinig kayo ha.
Yes, sir.
Yes, sir.
Yes, sir.
What was the topic last meeting?
Sir, formal and informal criminal justice system, sir.
Formal.
Recording in progress.
Come again, formal and informal.
Criminal and justice system, sir.
criminal justice system, formal and informal. Okay? So I think this is it. Is this it? Nasaan ka na? Ito ba yun?
Yes, sir.
So we have two justice system, the formal and informal justice system. When we say informal, it is the justice system in an unwritten way. Kumbaga, tradition siya, culture. An example to this is the historical CGS or criminal justice system of then Lapu-Lapu and the tribe. Diba? So kung may nagkasala, si Lapu-Lapu ang uhutal, ang hahatol pala, siya magbibigay ng punishment, and siya rin ang mag-execute ng punishment. That is an example of the olden way of informal justice system. While informal justice system, we are talking of the 5 pillars. So kaya siya formal because it has a system. It follows a system. And those systems are governed by laws. So I believe we have discussed this, the 5 pillars, last meeting. Even this. Kulang yung na-take down notes mo. Sumobra tayo dyan eh. Natapos na natin yun. Ito components of police. Excuse me. So, the two components of police refers to formal and informal. This formal consists of our PNP, the NBI, LTO, and other government law enforcement agencies. While when we are talking of informal component of police, it is composed of the citizenry or private sector. The citizens are also part of the police who are doing it on a part-time basis. This is anchored in Robert Peel's sayings, which states that the police is the community and at the same time, the community is the police. So, dyan bumabase ang informal. So, we have discussed this last meeting. Even these ones. Historical development of our Philippine National Police. So, what was the name of Napolcom before it was named such? Class. Anong tawag sa anong pangalan ng Napolcom noon? Polcom, di ba? Polcom. Bago siya naging Napolcom.
Yes, sir.
And the Philippine Constitution became PCINP, the merging of the Philippine Constitution and the Integrated National Police. So it became PCINP before it became PNP, or the Philippine National Police, as stated by RA 6975. So if in your exams later on, it refers to law, yan, reorganizing the DILG and establish the Philippine National Police, the BFP, and the BGMP, your answer is RA 6975. And after RA 6975, here comes your RA 8551, otherwise known as the PNP Reform and Reorganization Act of 1998. Mukhang na-discuss naman yata natin lahat to.
Sandaang taon
Yes, we have watched this short video. Okay. So in the past board exams, this some of these informations had been asked. The first Filipino chief of the PC in 1917 is Brigadier General Rafael Crame. And the first Filipino chief of police of the Manila Police Department in 1935 is Colonel Antonio Torres. And Colonel Lamberto Javalera is the first chief of police of the Manila Police Department after the Philippine independence from the United States of America in 1946. We have here Police Director General Cesar Nazareno, the first chief PNP, Chief of the Philippine National Police. Police Director General Cesar Nazareno. Take note of that, of those, ladies and gentlemen. Kindly read that for a while. So we have here NAPOLCOM, or the National Police Commission, an agency attached to the DILG. So take note of this, ladies and gentlemen. DILG, below DILG, we have the NAPOLCOM. And under the NAPOLCOM, we have the tri-bureaus, the PNP, BFP, and DILG. So, the Department of Interior and Local Government. So, yan ang DILG. The Interior refers to the tri-bureaus, the Interior Government, and the Local Government refers to your local chief executives, such as your mayor, and so on and so forth. So, yan ang local government. Compared to your IG, Interior Government, yan yung tri-bureaus. So the Manning levels, police to population ratio is 1:500. But this is obsolete nowadays because as per PSA, we have a ratio of about 1 to 750. One police per 750 personnel. I know, not personnel, persons, I mean. So the minimum police to population ratio is 1:1,000. And the average is 1:500 for the police to properly manage the community. So yan, sa isang community na may 500 na population, dapat may isang police. In every 500 population of the community, there should have a police. Oh, kindly check your mic. So, what is arrest? So, arrest is a method of arrest. Method of arrest by officer by virtue of a warrant. So, when making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of the arrest and of the fact that a warrant has been issued for his arrest, except when he flees or forcibly resists before the officer. Then the officer has the opportunity to inform him of when the giving of such information will imperil the arrest. So that is the conduct of arrest by virtue of a warrant of arrest. So paano ba nanghuhuli? In Tagalog, paano ba tayo nanghuhuli ng ng offender na mayroon ng warrant? Diba, lalapit yung police. Then the arresting officers will be identifying themselves as police officers. They will warn the person to be arrested. Yan. So, police ito. Police kami. Napapaligiran ka na namin. Napapaligiran na kita. Huwag ka nang manlaban. Di ba mga ganyan? Ikaw ay inaaresta dahil sa salang pagpatay. Yan. So, we have to inform him of the nature of the arrest. Then, after that, we will inform him of his Miranda rights. So, what is again your Miranda rights, ladies and gentlemen? The Miranda rights are as follows. To inform the arrested person of his rights to remain silent, di ba? That anything he says can be used against him. That's the first one. And the second one is to inform him of his right to an independent counsel of his own choice. That if the government cannot provide him, that if he can't afford if he can't afford the service of one, the government will provide for him. So, which will be coming from the public attorney's office. So, the officer need to have the warrant in his possession at the time of arrest. But after the arrest, if the person arrested so requires, the warrant shall be shown to him as soon as practicable. Now, I have a question, ladies and gentlemen. Pedro, a known wanted person, was seen by a police officer. The police officer properly identified Pedro, but the problem is he does not have the warrant of arrest in his possession. can the police officer immediately arrest Pedro? So class,
Yes, sir.
o si would like to justify. What's
Yes, sir.
your
Pwede, sir. Kasi nakot na siya sa akin na gumawa siya ng isang crime. Kaya pwede na siyang ma-aresto ng isang pulis. Dahil isang pulis din na nakakita sa kanya, sir.
no, I mean he was not doing a crime when he was about to be arrested, but the police officer knew that he has a pending warrant of arrest. The problem is the police officer failed to have it in his possession during that time. Can the law enforcer arrest Pedro?
Yes, sir.
Yung sinabi mo kasi na pwede siyang i-arrest because he has just committed a crime. So parang warrantless arrest yung sinabi mo. We are talking here of an arrest by virtue of a warrant of arrest. Who, by the way, who did try to answer that? Anong pangalan?
Lucas, sir.
Lucas.
Yes, sir.
Sige, Lucas.
Thank you, sir.
Who has any other answer? Aside from Mr. Lucas, meron ako narinig kanina.
Brutas po, Brutas.
Ay, Brutas.
G-R-U-T-S. Brutas.
Brutas. Okay, sige. Sorry.
Yes, sir.
Aside from Mr. Brutas. Asan ka na? Yung gustong sumagot kanina. Nawala na? Di nyo ba naintindihan yung tanong? Police officer knew that Pedro has a pending warrant. During the service of that warrant, Pedro cannot be found. Yan. So, hindi siya mahanap nung sineserve nila yung warrant, nung dala nila yung warrant. But incidentally, one day, police officer, while in the market, dagdagan natin yung kwento, while in the market, chanced upon Pedro. So, nakita niya, ay, si Pedro to ah. But the problem is, he did not bring with him the warrant of Pedro. Can the police officer arrest Pedro?
Yes, sir.
O yan, sige. Justify your answer.
Sir, kasi di ba sabi mo, sir, nung una, wanted siya, sir. Sir, nasa blacklist siya ng, ng police, kaya pwede siyang arestuhin, sir.
O, pero ang requirement niya dito, dapat daw may warrant of arrest bago mo i-arrest ang tao. Na pagka tinanong nung arestuhin, asan ang warrant ko? Pakita mo nga kung may sala talaga ako. Ipapakita mo daw. What's your remedy in that scenario?
Sir,
Ika-clarify doon sa sa police station, parang ganun, sir.
Okay. Anong pangalan mo?
Pedong, sir.
Pedong. Sige, sino yan? Sino yung gustong sumagot? Sino pa yung may additional?
Sir, yes.
Yes. How and why? Or how?
Sir, since nakahatulan naman na siya na guilty, since na bigyan na siya ng search warrant in the past, counted na po siya na fugitive. Arrest warrant. Considered na siya na fugitive kahit natakasan niya.
Yes. Ang gusto ko lang marinig naman is that's the general rule. In arrest via warrant of arrest, ang general rule dito is hindi nyo kasi nasabi, pero ito yung ginanap kong sagot. The general rule is in arrest via warrant of arrest, you should always bring with you the warrant of arrest, di ba? Na yan, na ipapakita nyo sa wanted person upon his arrest after you have warned him of his rights. Ganyan. But the problem is, hindi nyo dala yung warrant of arrest. First, your answer in stating, yes, he can be arrested is correct. Diba? So, tama yan. But the justification and the alternative solution was not answered. So, yes, pwedeng i-arrest yan. So, what should be your alternative? Kasi ang general rule, dapat dala mo yung warrant of arrest na ipapakita mo sa tao upon or during his arrest. Hindi mo nadala. So, pwede rin yun, yung nasabi ng kasama nyo, bring him to the nearest police station. Yan. And access on that, their database on wanted person. So, ganun na ngayon. Meron nang sa investigation section ng mga municipal police stations and city police stations, meron silang tinatawag na e-warrant or electronic warrant, wherein the investigator will just encode the name of the person in that system and his warrant of arrest will appear and can be printed. So, yan. Tama yun. So, ganun ang sistema ngayon. Mostly habang nagka-high-tech na tayo, mga electronic na rin. Nasasave na rin sa electronic devices yung mga soft copy ng mga warrant. Aside from warrant, meron din tayong yung mugshot na sinasabi, di ba? So, what is mugshot? Mugshot refers to the picture of any suspect or arrested persons, di ba? Or wanted persons. Yan ang mugshot. Or sometimes, as a result of development, we now call it rogues gallery. Ngayon, sa modern era, nowadays, we also have the term e-rogue system. This e-rogue system contains pictures of wanted person and arrested persons. So, yan naman ang e-rogue. Just like your e-warrant contains an electronic copy of the warrant of arrest. Your e-rogue contains an electronic copy of the picture of the arrested persons or wanted persons. So long as it's available. Kasi meron din tayong mga wanted person na first-time offender, wala pang mukha sa database. So, not reliable in all cases yung e-rogue system, yun lang. But if we are looking for a picture of a person who had been arrested, yan, so pwede nating makita yan sa e-rogue system. Ito ang itsura niya. So, yan. Who did answer after Pedong? Sino pala yun? Sino yun? Yung sumagot kanina after Pedong.
Ako ata, sir.
O nga, anong family name mo? Di ko na...
Ay, sorry, sir. Chinanglas po.
Taga-Bontok, di ba? Chinanglas.
Yes, sir.
Now, following the arrest via warrant of arrest, we also have the what we call warrantless arrest or arrest without warrant. So, yan na yung mga instances ng warrantless arrest when in the police officer's presence or in the civilian's presence, kasi pwede rin kayong mag-arrest mga civilian. Diba? Pwede rin. Kaya siya tinawag na, what is the other term for warrantless arrest? It is also known as the citizen arrest. Citizen arrest niyang tawag dyan. So when in his presence, the person to be arrested has committed. So gumawa ng krimen, in flagrante delicto, or is actually committing, or is attempting to commit an offense. So yan. Kumbaga kung kayo, citizen's arrest, habang nandoon kayo, you have personally witnessed a person who had committed a crime. Pwede nyong i-arrest yan. Who is actually committing a crime. Nandurukot sa overpass, nakita nyo. O pwede nyo nang i-arrest yan. Or is attempting to commit an offense. Kumbaga, siguro nang-attempt na gumawa ng krimen. So, pwede nyo nang i-arrest yan. Second instance, when an offense has in fact just been committed. So, magkaiba yung first instance sa second instance, ha? In the second instance, you, as the arresting person, is not necessarily in the place of the crime. Kumbaga, hindi nyo personally necessarily na nakita, na na-witnessan yung commission of the crime. But, a crime had just been committed. Sure kayo, you are certain that a crime had just been committed and you, as the arresting person, has personal knowledge of facts and circumstances indicating that the person to be arrested is the person who had committed the crime. So take note of the term personal knowledge. Magkaiba ang personal knowledge sa hearsay. Okay, guys? So iba ang hearsay sa personal knowledge. May nangyaring krimen. Tapos, yun yung suspect. May personal knowledge kayo na, ay, siya yung gumawa. Bakit siya yung gumawa? Pula. Pula yung nakita mong tumakbo galing dun sa place of incident. Hinabol mo. So, you have the personal knowledge. Ang problema kasi, kung hindi personal knowledge, ang pagbabasihan nyo, uy, nakapula-pula. Yung suspect pala yung nagsabi nun. Pinasubo niya yung nakapula. Ngayon, nakataka siya ngayon. Yung nakapulang hinabol nila, siya nakaitim. Siya yung gumawa. So, yun ang problema sa personal knowledge compared with the hearsay. So, personal knowledge. When an offense had just been committed and the arresting officer had a personal knowledge based on facts and circumstances indicating that the person to be arrested is the one who had actually committed the crime. So, ito naman yung pinakamadali. So, a peace officer or private person may, without a warrant, arrest a person when the person to be arrested is escaped prisoner. So, tumakas sa bilangguan. So, yan. Pag tumakas sa bilangguan or sa jail, automatic. Pwedeng i-arrest yan. We have here the term discretion. Discretion is the wise use of one's judgment, personal experience, and common sense to decide a particular situation. So, discretion sometimes is termed as the sixth sense. Yan. Kumbaga, it is gained through experience. Yan. So, ano kaya mangyayari after this? So, kung hindi ako puputok, baka mamatay na ako, mga ganyan, yung mga nag-gain ng mga police experience. So, that is discretion. Police officers are decision makers and most of their decisions are based on discretion. So, it depends on the scenario and based on their experience. So experience plus scenario, that is the basis of discretion. On how to respond to a particular incident. Mhm. Ano yan? So ladies and gentlemen, let's have 5 minutes break and I'll send you another link.
Recording stopped.
Present, sir.
Yes. Si Ma'am Cha pala, siya palang instructor sa tabing room supposedly natin, sa room 202. Hinahanap ako. Nasaan daw tayo? Okay, so kindly open cam. Again, I'll be sharing my screen. So can you see my screen?
Yes, sir.
I believe we had also discussed this prosecution last meeting, di ba? Natapos rin natin to. Tatlong links kasi yon, hindi yata kasi kayo nakapag-login dun sa sumunod na link. Okay, so prosecution is the process or method whereby accusations are brought before the court of justice to determine the innocence or guilt of the accused. So it is the process or method whereby accusations are brought before the court of justice to determine the innocence or guilt of the accused. So under the prosecution, who is the prime mover? We have what we call prosecutor. So he is not just an ordinary official of the government. He is as well an officer of the court. So Department of Justice is under the Department of Justice, we have the prosecutor. Yan. Diba? We also have the court under the Department of Justice. The National Bureau of Investigation is also under the Department of Justice. So yan yung mga under sa DOJ. So the prosecutor is under the Department of Justice along with the Public Attorney's Office. So the prosecutor is responsible for carrying out administration of the criminal justice system through an adequate examination of offense charge. So what do you call his adequate examination of the offense charge? It is termed as preliminary investigation. So wag na wag niyong kakalimutan yung term na yun. Preliminary investigation is to determine the probable cause. Yan. To determine probable cause for the offense. Napag-usapan na rin natin to last meeting. Naalala mo pa to, Mr. King Carbonell? Diba? I have already explained this. Ay, King. Babae pala ang King.
Sir, kakapasok ko lang po dito. Ano po yan? Kakauwi ko lang po.
Sige, okay lang. Diba natapos na natin to last meeting? O wala ka last meeting?
Meron po ako.
Sir, hindi po natapos to.
Absent ka last meeting. Naalala ko, in-explain ko pa to eh.
Hindi, sir. Promise.
In-explain ko to last meeting. Diba sinabi ko pa na?
Sir, awan pa yan mo na rin discuss nila.
Di kayo nakikinig. Diba sabi ko, plea bargaining, hindi dapat siya under sa prosecution. Under sa court dapat siya. So what is plea bargaining? Yan, medyo malabo ka, ano? L. Okay lang. Malabo ka, L. Zairil. Malaki naman siguro to, di ba? Malabo, mahina yata yung data mo. Explain na lang natin. So, plea bargaining is the process of discussion or negotiation. So, when we say negotiation, there is a negotiation happening between the defendant and the prosecution's side. Even case there are probability for a plea to a lesser offense. So, yan lang yung plea bargaining. Aminin ko to, pero baka pwedeng mabawasan naman yung penalty ko. Mga ganyan ang plea bargaining. Ronald, mic mo. Now, as a result of your warrantless arrest, if you had arrested a person via warrantless arrest, you as a criminology students, what will be the next step you will be undertaking? Well, upon arrest, you will be turning over that arrested person to the nearest police station. And of course, relate to them the information and the crime he had committed. So, yun ang gagawin nyo doon. If you had to sign document there, if you had to do an affidavit, then you have to. Most likely, pagka kayo yung arresting persons who did the citizen's arrest, you really are, it is not normal for you to be required to do an affidavit. And it is called affidavit of arrest. Yan. So, ikukwento nyo doon, sasabihin nyo yung personal circumstance nyo sa first paragraph. I so-and-so of legal age, yan, while traversing at the market, so the suspect picking the cell phone of the victim from the victim's pocket. Mga ganyan, ikukwento nyo. Then after that, upon seeing that, I immediately apprehended him. Kung mas malakas kayo sa kanya. Kung hindi mo kaya mag-isa, pwede namang magtawag ka muna ng backup. After seeing that, I encouraged the community to help me arrest the perpetrator. So, pwede rin yun. Now, after that, you will be delivering the arrested person to the nearest police station or to the nearest compact. Diba? And in the nearest police station, they will prepare the case folder. And the term in filing that case is termed as inquest. So, yan na yung inquest. It is an informal and summary investigation conducted by public prosecutor in criminal cases involving persons arrested and detained without benefit of warrant of arrest. So, inquest proceeding ang gagawin ng police and prosecutor dyan. Unlike if the person was not yet arrested but he was identified and the case was filed against him, the filing of the case or the filing of that case is termed as direct filing. Diba? So, direct filing versus inquest proceeding. Magkaiba yung dalawang yon. So, direct proceeding applies only to what? Filing of cases wherein the suspects were not arrested. So, yun ang direct filing. So, inquest proceeding naman, this is the proceeding conducted to all offenders who were arrested via warrantless arrest. Warrantless, walang warrant. So, yun yung difference nila. Kumbaga, two types of filing cases, your inquest and direct filing. Magkaiba naman siya sa two types of arrest. Two types of arrest are your warrantless arrest and arrest via warrant, through warrant. So we have here a complaint. Complaint. Yes, Miss Claudine, kindly check your mic. Complaint is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officers or other police officer charged with the enforcement of law violated. So, complaint, yan yung sworn statement charging a person with an offense. So, yan yung pinakaunang attachment ng case folder na isang kaso. Complaint. Tapos, after the complaint, the affidavit of witnesses. And after the affidavit of witnesses, follows the pieces of evidence. So, yan ang laman ng case folder. Now, in lieu of complaint, we also have the information. Information is a charge sheet filed by the prosecutor in court. So basically, information and complaint are similar in a way that they contain the complaint, yung nirereklamo ng biktima. They only differ in the person who prepared the document. So, complaint is prepared by the law enforcer, yan, yung police, or even private lawyers. So, yan, complaint. Tapos, prosecutor naman prepares the information. So, yan, pagka information ang gumawa ng reklamo, kahit pagka prosecutor ang gumawa ng reklamo, we call it information. Pero pagka police or private lawyer, we call that document a complaint. Okay? Mr. Kayusa? Naintindihan mo ba? Yung, tandaan nyo itong mga to, itong mga term na to, hanggang sa law 4B nyo, gagamitin tong terms na to. Complaint and information, warrantless arrest, warrant of arrest. Now, arraignment. We have now the term arraignment. It is the legal mechanism whereby an accused is brought before the court wherein the complaint or charge against him is read by the clerk of court in the presence of the offender's lawyer or his defense counsel, the prosecutor in which the accused is to announce his plea. Yan. So, sino ang babasahan ng arraignment? Is it the complainant or is it the accused?
Accused, sir.
Of course, it is the accused. Arraignment is the reading of the accusation towards the accused. And after the arraignment, follows now the plea. Now, how do you plea? Sabihin, guilty or not? Guilty. If guilty, automatic, the offender is considered guilty, criminal na mismo. Umamin na eh. That's what we call judicial confession. So, judicial confession na ang tawag doon pag umamin. Pero how do you plea? Sabi niya, not guilty, then we have no choice but to proceed with the hearing kung not guilty ang sabi niya. So, after that, what's gonna happen? Preliminary investigation yung nakasulat dito. But what happens after the plea of not guilty is the pre-trial conference supposedly. So, stipulation of facts, pre-trial conference, yung mga yun ang nangyayari dapat doon. But let's just follow this flow. So, preliminary investigation, as defined in Section 1, Rule 112 in Rules of Court, is an inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed. So, yan ang purpose ng preliminary investigation being conducted by the prosecutor to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and that the person charged thereof is the person who had committed the offense. So, yan. So, what is the process of preliminary investigation? Excuse me. The submission of the complaint and affidavits of the complainant and witnesses, as well as the supporting documents to establish a probable cause. So, in short, the case folder being prepared by the investigator will now be given to the prosecutor, endorsed to the prosecutor, for the prosecutor to determine probable cause. Now, question. What is being determined during the preliminary investigation? Oh, Mr. Jeremy. Jeremy Agpad. Wala. Ito na lang. Who conducts preliminary investigation?
Prosecutor, sir?
Okay. Thank you. So, prosecutor again conducts preliminary investigation. What is the purpose of the prosecutor in conducting preliminary investigation? To determine
Probable
next.
cause.
Aside from Mr. Agpad, who would like to recite? To determine, ayun na nga, naka-highlight na nga in red. Hindi talaga kayo nakikinig. Nandiyan pa ba kayo? To
Yes, sir.
determine probable cause. Yan. So, yan ang purpose ng preliminary investigation. To determine probable cause. So, what is probable cause? Ano bang dapat nating malaman sa probable cause? Yan. To determine whether or not the person being charged of a crime is actually the person who had committed it. Yan. So, dapat mas malakas ang ebidensya. Kasi kung walang ebidensya, tapos akusa ka ng akusa, then there's no probable cause. Yan. So, saan ba nagbabase ang probable cause? Mostly on evidence. Otherwise, kung wala kang evidence pero akusa ka ng akusa, you are doing your own crime. Nagkakasala ka niyan. Pwede ka ma-countercharge dyan ng libel, defamation, ayan, and so on and so forth. Mostly civil cases. Pwede kang mamulta. That's hearsay or marites. So, yan. So, pag nagkakakusa tayo, make sure that we have an evidence para hindi tayo ma-countercharge. Excuse me. So, they shall be in such number of copies as there are respondents. So, kung ilan ang respondents, kung 2, 3, 4 yung kinakasuhan, dapat 3 rin yung kopya ng case folder for the conduct of preliminary investigation. Bakit? Because the respondents will be copy furnished of the complaint or information. Okay? So, ganito yung nangyayari guys. Pakinggan nyo to. Pagka nag-file ng complaint ang police sa prosecutor, yan, as part of the preliminary investigation being conducted by the prosecutor will subpoena the respondents to give their answer. Tapos, syempre, naka-attach doon yung complaint. Okay? So, after that, upon receipt naman of the respondent, yung kinakasuhan, after they have received the subpoena, yung subpoena, take note, ladies and gentlemen, that we have again two types of subpoena. Tatlo pala. First is subpoena at testificandum, di ba? Yung they issued subpoena to a certain person to testify during hearing. Yung second is subpoena duces tecum. So when we say duces tecum, we are requiring a certain person to bring the documents or the necessary evidence to the court. Yan. Tapos yung pangatlong uri is the combination of the duces tecum ad testificandum. Yan. Subpoena duces tecum ad testificandum is a subpoena requiring a person to bring the document or evidence to the court and testify in relation to that document. So yan. Or in relation to that case. So yan. As part of the preliminary investigation being conducted by the prosecutor will now issue a subpoena to the respondent, and the respondent shall submit his counter affidavit. Yan. So, dapat mag-submit ng counter affidavit yung respondent. Copy furnished to the complainant. Ngayon, the prosecutor will now assess the case based on the complaint of the complainant, of the victim, and again, and in relation to the counter affidavit of the respondents. If there's a need for the prosecutor to require the complainant to submit his answer to contradict his reply pala to contradict the counter affidavit, then the prosecutor may do so. But if the prosecutor is not convinced with the counter affidavit of the respondents, then the prosecutor will now endorse the case to the court. Yan, so he will now file the case to the court. Okay? So, ganun ang mangyayari. Pero, kung convincing naman yung counter affidavit ni perpetrator, then the prosecutor may outright dismiss the case. So, yun naman ang mangyayari pagka convincing yung counter affidavit ni respondent. Did you get that, class? Magagamit nyo itong sinasabi kong ito, magagamit nyo sa law 4 nyo, law 4 A and B. So, within 10 days after the filing of the complaint, the investigating officer shall either dismiss if he finds no ground to continue the investigation. Pag walang ground ang investigation, walang bearing, o kaya mas kapanipaniwala, mas convincing yung counter affidavit ni respondent, then the prosecutor may dismiss the case. Or, if the respondent failed to submit his counter affidavit within 10 days, or he has submitted a counter affidavit, however, it was not convincing enough to the prosecutor, then the prosecutor will now issue subpoena ulit to. The respondent attaching to it a copy of the complaint and its supporting affidavits and documents. But most likely, ang ginagawa ng prosecutor kasi ngayon talaga, nag-issue sila ng subpoena, nagre-require sila ng counter affidavit. So, within 10 days, the respondent shall submit his counter affidavit. So, within 10 days upon receipt of the subpoena, take note of this, ladies and gentlemen, pag may 10 days na, within 10 days, dapat makapag-submit ng counter affidavit yung respondent. If the respondent failed to submit his counter affidavit within 10 days from the receipt of his subpoena, then the prosecutor will decide the case based on the complaint. Necessary, ang nangyayari dyan, yun ang basehan, yung complaint. And what do you expect pagka yung complaint or information lang ang basehan ng preliminary investigation? Automatic, mapafile yan sa court. Kaya nga pagka kayo later on makakasuhan, nakareceive kayo ng subpoena, it's better for you to answer that subpoena rather than ignoring it. Kasi pagka in-ignore nyo yan, magugulat na lang kayo, biglang warrant of arrest na ang susunod. But if you had submitted your counter affidavit, at least you have a chance of dismissing the case being filed against you. So within 10 days after the investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial. So if there is, then he will now endorse the case to the court. He will file the case to the court through a resolution or information. And of course, the prosecutor shall certify under oath. So, pipirma pa siya under oath doon sa information or resolution na gagawin niya. Addressed, which will be forwarded to the court. So, within 5 days from his resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy in cases cognizable by the Sandigan Bayan. So, if the case is cognizable by the Sandigan Bayan, all of these offices from provincial, city, chief state prosecutor, and even the ombudsman shall be copy furnished of the said case folder. So when we say ombudsman, he is the prosecutor for graft and corrupt practices and any other crimes committed by government employees. So yan ang hawak ni ombudsman na kaso. He is the prosecutor. Tapos ang court naman ng ombudsman is called the Sandigan Bayan. Okay? So Sandigan Bayan. Now, they shall act on the resolution within 10 days from the receipt thereof and shall immediately inform the parties of such action. So, that's all for prosecution. Let's proceed with the courts. Class, have you seen Ma'am Attorney Charlene sa room 2 kanina? Yung pumuntang school? Napagkakalata kayo. Wala talaga kayo sa classroom kanina. Di ba?
Sir, wala. Wala namang...
Sir,
Nandun siya. Sa room
Sir,
2.
nung pumasok po yung mga estudyante niya, sir, umalis na po kami kasi magkaklase daw po sila.
Sa room 2 siya. Sa 2-3 tayo eh. Okay lang.
Tabalya Gord.
So the court is the centerpiece of the 5 pillars. So pag centerpiece, 5 ang pillars natin. Siya yung pangatlo. As such, it performs perhaps the most important role in the administration of justice because it is the court that everyone turns to for justice. Now, a court is the body to which the public administration of justice is delegated, being a tribunal officially assembled under the authority of the law at the appropriate time and place for the administration of justice. So, at the court, we can see a judge. At the prosecution, we can see the prosecutor. At the law enforcement, we can see the police. Those are the prime movers of those pillars. Now, in relation to court, who is a judge? A judge is a public officer so named in his commission and appointed to preside and to administer the law in a court of justice. So, he presides hearing. So, siya nagpre-preside ng hearing. So, we have here the distinction between court and judge. A court is an incorporeal entity. Incorporate entity. So, yan. So, when we say incorporate entity, buo siya. Isang buong entity, organization. Composed of one or more judges. It has a personality, separate and distinct from the men who composed it. So, iba yung identity ng court doon sa gumawa sa court pillar. A judge alone does not necessarily constitute a court. For while he is an indispensable part, he is only a part of the court. So the court is bigger than the judge. What time is supposed 7:20, di ba? Ang dismissal natin.
Yes, sir.
So, after this, kung magsara to, meron ulit akong pangatlong link ha. Huwag kayong maglalag out. Tapos sabihin nyo, ay, we haven't discussed that last meeting. Pagtsakan muna natin itong free version ng Zoom. Wala, hindi ko pa afford bumili. So, others in the courtroom work group. So, court administrators. Who are these court administrators? These government employees are usually appointed by the state court of last resort to act as statewide court administrator. So, in lieu of judges, pag nagkulang sila, then the government employs court administrators. We also have the term court clerks. They are responsible in maintaining the court's records. Yan. So, they maintain the record. They prepare daily calendar. When we say calendar, the court calendar. Kung sino ba ang may hearing on this day, mga ganyan. Calling cases before the judge. Yan. So, pagka mag-umpisa ng hearing, di ba? Pagdating ni judge, all rise. So, lahat tatayo. Sabi ng clerk, all rise. Tatayo silang lahat. Tapos, the court is now in session. Sabay hampas ni judge ng martilyo niya. So, from that, the clerk of court will now call cases to be heard. So, first, hearing, criminal case number so-and-so. Tapos, hahanapin yung parties. So, when we say parties, we are talking of the accused, yung biktima, and the accused yung offender, and the complainant or the victim. And aside from them, of course, the court will also look for the prosecutor, the representative of the complainant, and the defense counsel, the representative of the accused. Controlling evidence in court, so they control the presentation of evidence in court and collect fines and court costs. So, yan ang trabaho ng court clerks. We also have the term bailiffs. So, bailiffs, these are the court personnel who perform a variety of duties including maintaining order in the court, announcing judge entry into the courtroom, calling witnesses, controlling defendants, and supervising juries. So, yan ang trabaho ni bailiff. So, yan take note, ladies and gentlemen. Sinama ko pala yung kanina. Instead of the clerk of court, ang magsasabi pala ng all rise is the bailiff.
Recording in progress. Recording stopped. Recording in progress.
Sir, present.
Yes, I know. Nire-reply ko lang si Tony. Okay, so allow me to share my screen again.
Yes, sir.
So as usual, can you see my screen?
Yes, sir.
Mhm. So aside from clerks and bailiffs, we also have the court reporters. So they are sometimes referred to as court stenographers. These people report everything said in court. So how do they report? They record, kumbaga. So sila yung nagsusulat. These stenographers, kung minsan nakikita nyo yung court na, yung personnel sa court na nagsusulat. Kunwari, may sinabi yung witness, tapos may nakita yung nagsulat. So yun yung stenographer. They record everything that transpires in court. And at the same time, their record now reflects their report. It becomes now their report. That is your court reporters or court stenographers. Glory Babes, Banasan, Banagan. Can you check your mic?
Present.
And we also have other persons in court. We have witnesses. So either lay or expert. So we have two types of witnesses, the lay or ordinary witness and your expert witness. Most of your expert witness are representatives from your forensics group, di ba? They are sometimes fingerprint experts, ballisticians, and so on and so forth. So the lay witness testifies in court about something he observed in a crime. So take note of this, ladies and gentlemen, the difference between your lay witness and your expert witness. Your ordinary or lay witness testifies in court about matters he had personally witnessed or noticed or observed, while your expert witness testifies on matters which he had not actually witnessed, but he can give his expert opinion on in relation thereto. Yan. So, expert witness includes your ballistician, your fingerprint experts, your QD experts, question document experts, anthropologists, chemists, toxicologists, zoologists, dentists, psychologists, and so on and so forth. Marami yan. So, those are... Are you okay, Miss Robin Joy? So, in the criminal justice system, the court is looked upon as the final arbiter for justice. Yan. So, it is looked upon as the final arbiter of justice. Kung hindi nakukuha yung justice sa barangay, then we have no choice but to elevate it with the court. So, ganyan. So, the court is the frontline defender of democracy, freedom, and human dignity. So, whenever there is abuse of the government, then the court may intervene. Diba? So, because we are a democratic country, supposedly, all that transpires in Philippines, all laws being created in the Philippines must be created by the majority. So yan ang purpose ng democracy. Now, in relation to our laws, I have a question. In relation to our laws, since laws are supposed to be created in line with democracy, then there should be a majority. Tama? Tama ba, class?
Yes, sir.
Yan. Buti pa si Mr. Bangibang. Now, question. Are we being represented during the creation of laws in relation to democracy? Nasasama ba tayo sa pagbibilang ng majority sa paggawa ng batas? Are we or are we not?
Are
Are we? We are. Yes, of course, we are. We are being represented by the Congress. Yan. So tayo, na kahit na hindi tayo umaattend during congressional hearing or during proposal of bills, di ba? Kasi ang batas, bago maging batas yan, bill muna yan na pinopropose ng Congress. Now, we are being represented by the Congress. So yan. Ngayon naman, in terms of the majority or democracy, kung boto yung mas maraming Congress, then they allow it, they permit it. Diba? So, still we are being represented. So, yan ang democracy. Now, the only institution capable of identifying and maintaining the proper balance between conflicting rights of individual and those of the state and society. So, the court is the only institution capable of identifying and maintaining the proper balance. Kaya nga si Lady Justice, ang hawak niya, weighing scale, di ba? So, dapat balance. Walang agrabyado. Walang pinapanigan ang batas. Yan. The conflicting rights of the individual and those of the state and society. It is the courts that everyone turn for justice. So we have here the first level courts. So when we say first level courts, they are the MTC, MTCC, MCTC, and Metropolitan Trial Courts or METC. Now here in Baguio, we have how many of these four can you observe? Yeah, gawin ko ang Q&A para mapaisip naman kayo. Who would like to answer? Buti pa si Mr. Bangiban. Are we lang ang sinagot niya? Mayroon ng recitation. Who would like to answer? In the province of Baguio and in the city of Baguio and in the province of Benguet, among these four first level courts, what can you observe that we have? Ayaw niyo sumagot? Sige, ako na lang.
Sir RTC.
Ha? Mr. Robert? What?
Sir RTC.
No, RTC is in the second level court. first
Ah,
level
sure,
court
sure.
pa lang tayo. Yan o, MPC, MPCC, MCTC, and METC. Ano yung meron sa atin na nakikita nyo sa Baguio and Benguet?
MTC, sir.
MTC, sir.
MTC, sir.
MTC.
Oh, aside from MPC, what else?
MTCC.
MTCC.
Now, question. Where do you see MTCC? Where do you see MTCC? Saan? Sa Baguio or Benguet?
Baguio, sir.
Baguio, sir.
Oh, aside from that, ano pa nakikita nyo? Who are from the municipalities of Kabayan, Kapangan, Kibungan? Wala. So, MTC, Municipal Trial Court, we have that in Itogon. Yan. Diba? In La Trinidad, MTC. So, La Trinidad, MTC. Means to say, isang municipality, isang MTC. Yan ang MTC. Yung MTCC naman, Municipal Trial Courts in Cities, refers to MTC in cities. Kaya yung MTCC, tama yung sagot nyo kanina, nakikita lang natin yan sa bulwagan ng hustisya, the Justice Hall at Baguio Justice Hall, doon sa likod ng City Hall. So, mayroon yan, MTCC 1, 2, 3, and 4 yata yun. We also have the MCTC within Benguet. So, Municipal Circuit Trial Courts. So, why do we call it circuit? Because it is a court within a particular municipality which handles cases of 2 or more municipalities. Circuit municipalities. Kaya siya municipalities. Let's say for example, Kapangan and Kibungan, di ba? Dahil kukunti lang ang kaso ng Kapangan at kukunti lang din ang kaso ng Kibungan, ginawa silang circuit courts. Their circuit court is found in Kapangan. So pagka may kaso ang Kibungan, doon nila tinatry sa circuit court na yon na matatagpuan sa Kapangan. So that is the Kapangan-Kibungan Municipal Circuit Trial Court. So yan ang MCTC. Gets? Plus? Oy.
Yes.
Tulog-tulog. Huwag kayong matulog. Wala pa. 7:20 pa ang dismissal natin. Anong oras? Alas 7 pa. Meron pa tayong 13 minutes na lang. Yes, makakakain na rin ako. Now, where do you see METC? Metropolitan Trial Courts. Only in
Manila, sir.
Yes. Thank you. Only in Manila. So, courts of the first level are essentially trial courts. Yan. So, take note of this, ladies and gentlemen. MTC and your RTC are trial courts. So, when we say trial courts, nagtra-try sila. Sila yung nag-hearing proper talaga. So, dyan talaga magte-testify yung mga witnesses. Mag-represent yung mga evidence. Okay? So, those are your trial courts, MTC and RTC. Appellate court naman ang tawag sa Court of Appeals pataas. Court of Appeals, Supreme Court. Appellate court naman yan. Okay? So, courts of first level are essentially trial courts. They try and decide only particular types of classes of cases specified by law. So, if the penalty for a certain crime is 6 years imprisonment, it will be handled by your RTC. If it is less than 6 years, it is handled by your MTC. Diba? So, yun ang distinction niya. Now, we have here the second level courts. At the second level are the RTCs. Like the first level courts, RTCs are also trial courts. So, trial court din ang regional trial court. Now, I would just like to inform you guys, that we have a misnomer in regional trial court. When we say misnomer, maling pangalan. Diba? Mali yung pangalan niya. Hindi siya dapat na RTC. It is supposed to be provincial trial court. Tignan nyo, yung mga nasa Baguio, RTC ang tawag. Yung nasa La Trinidad, aside from MTC, yung mas mataas sa MTC, RTC. Diba? Those are supposed to be provincial trial court sana daw, hindi daw regional. So, municipal trial court, La Trinidad Municipal Trial Court, di ba? RTC of Benguet. Sabi niya, Benguet, ano ba bang Benguet? Is it a region or a province? Province ang Benguet, di ba? Kaya siya misnomer. Kaya Benguet Police Trial Court, Benguet Provincial Trial Court dapat siya, hindi siya Regional Trial Court. Pero yan na yung nakalagay sa batas, then it has to be amended bago natin baguhin. Kung hindi na-amend ng batas, let's stick with what's written on the law. So, the RTC are courts of general jurisdiction. They try and decide not only the particular classes or kinds of cases assigned to them by law, but also those are not otherwise within the jurisdiction of courts of first level. So, yan. So, general jurisdiction ang RTC. All those cases not falling under the jurisdiction of your MTC is falling under the jurisdiction of your RTC. So, let's say for example, ano ba ang prerequisite bago natin sabihin na ang kaso ay cognizable within the RTC? The penalty, dapat may 6 years penalty, di ba? So, yan. Now, the question is, what court should have a jurisdiction if the penalty has less than 6 years of imprisonment, but it was not cognizable under the MTC. Kumbaga, hindi siya nakaregister sa MTC. Pero less than 6 years. So, sino ang dapat mag-try? Is it the MTC or the RTC?
RTC, sir.
Ayun, tama. So, nakalagay na nga dyan. All cases not cognizable under the MTC falls under the jurisdiction of the RTC. So, aside from your first and second level courts, we have the third level courts. At the third level court is your Court of Appeals. It is essentially an appellate court, reviewing cases appealed to it from the RTC. Yan. Although MTC cases may also be appealed to RTC, still may magkakaroon pa rin ng trial doon. So, appellate court, Court of Appeals. It may review questions of facts or mixed questions of fact of law. So, in other terms, the facts or the issues being resolved by the Court of Appeals are questions in law. Diba? Kung may questionable sa batas na mahirap intindihin, mahirap i-interpret, so yun ang nire-resolve ni Court of Appeals. But as to the facts of the case, it is already determined by your MTC and your RTC. So, yun ang difference, okay? Sa MTC and RTC, ang trial natin doon, the facts of the case. Nire-resolve natin yung issues pertaining the facts. of a case. And in your Court of Appeals and in the Supreme Court, ang nire-resolve na issue dyan is on the questions in the law. Questions in the interpretation of the law. Kumbaga. Kaya kung minsan kung may mahirap tayong intindihin na batas, ang ginagawa pa ng mga law experts is they rely on the interpretation of the Spanish. Bakit? Because your RPC, your Revised Penal Code, is anchored from the Spanish law. Your fourth level court now is the Supreme Court. It is the highest court of the land. So, it is not an appellate court. It is now called a review court. So, review court na ang Supreme Court. It is the court of last resort for no appeals lies from its judgment and final orders. So, pagka dinicidean na ng Supreme Court yan, wala nang mas tataas sa Supreme Court. So, means to say, the decision is now final and executory. It can no longer be appealed. Wala nang mas tataas pa sa Court of Appeals. So, pagka decided ng Supreme Court na kinonvict si Pedro sa criminal case, then we can safely call Pedro a criminal. But if it is the MTC who convicted Pedro, there's a probability for Pedro to appeal. And still, kung nag-appeal yan, he hopes na mabaliktad yung judgment, ma-revert yung judgment. Kaya, is it safe to call Pedro a criminal after his conviction to MTC? Not yet. Unless his 10 days for appeal has lapsed. Kung nag-lapse na yung 10 days to appeal niya, hindi siya nag-appeal, then the decision of the MTC convicting him is deemed final and executory. So, yun din naman. So, in court, we have what we call jurisdiction and venue. Yan. So, what is jurisdiction? Jurisdiction is the authority to hear and the right to act in a case. So, yan ang jurisdiction. So, means to say, does the RTC have a jurisdiction on cases with penalty less than 6 years? No. Those cases with less than 6 years imprisonment are supposed to be under the MTC. MTC has jurisdiction over it. Kumbaga. So, where did the crime commit? Where was the crime committed? So, yan din ang jurisdiction. Venue pala yun. So, kung saan nangyari yung krimen, doon din dapat ma-file yung kaso. If the case is punishable less than 6 years imprisonment and it happened in Baguio, then the case must be filed and heard in Baguio. So, yun naman ang venue. Now, jurisdiction is the power of the judges to administer justice, that is, to try and decide cases in accordance with laws. So, yan, yung mga judge natin, yung mga decision din ng mga judges natin are all aligned with law. May basehan din sila dyan. So, we have here general authority. General authority of court over cases in general. It is the authority to decide all disputes which may come before it except those assigned to other courts. And exclusive. Exclusive is the authority of the court to take cognizance of case to the exclusion of other courts. So, yan. So, oras na hinandle ng court ang isang kaso, hindi na pwedeng i-handle ulit din ng ibang kaso. ay ibang court. Yan. So if a case was already decided by RTC Baguio, it cannot be, the case can no longer be tried in other RTCs. Kumbaga ganyan. And that is in relation to your double jeopardy. Di ba? So bawal na makasuhan ng isang akusado twice in relation to one certain act. So concurrent and limited. Concurrent is the authority granted to two or more courts to take cognizable of particular cases. So when we say concurrent, yung may tinatrial yung court ngayon, and at the same time, pwede pang malagdagan yung load niya while hearing the first case being tried. Diba? So, kumbaga, parang in addition to the case you are trying, these are also added in your load for you to try and hear. Yeah. Limited or special is the authority of the court over specific cases expressly enumerated by law. Mostly, explanation falling under this limited or special is cases involving the RA 8353, your rate, and 9262, yun. O kaya violation of your PD 603, the rights of children. Lahat ng mga kaso involving those are being tried in the special court named family courts. Yan. So, yan ang special family courts. Meron din tayong drug courts, special court din yan. Lahat ng mga violation ng provisions or laws on drugs are being tried by your drug court. So in Baguio, meron tayong specific drug court. Di ko lang maalala kung anong branch yun. Meron din tayong family court. Di ko lang din maalala kung anong court yun. So isang RTC court for drug cases at isang RTC court for family-related cases. So criminal, authority to decide punishment for a crime. Tapos civil, that exists when subject matter is not of criminal offense. So pagka yung kaso hindi nag-fall sa criminal, then pwedeng civil aspect. Diba? Pwedeng may civil aspect yung case. Appellate, when it can already heard and decide, when the case was already heard and decided by the lower court and appeal to higher court. Sandigan bayan na. So with that, ladies and gentlemen, time check, it's already 7:22. Nag-exit pa tayo ng 2 minutes. Do you have questions?
None, sir.
Sir.
Na kayo. Uwi na. With that,
Pinanganon.
with that, ladies and gentlemen, thank you very much. See you tomorrow. Through online.
Recording stopped.
Thank you, sir.
Sige.
Sir,
Sir,
online tayo bukas, sir.
sir,
Online tayo bukas.
sir,
Sige,
baka
sir.
provide mo nga reviewer, sir.
Hi, Wen. Sige,
Hello,
sige.
guys.
Sir, pa-share on the link.
Yes.
Reviewer,
Don't
sir.
worry. I'll be sending.
Sir, pa-send mo ng PPT.
Pag-review nita kasi digti exam.
Oh,
Sir, pa-send ng
Reviewer, sir.
kailan ba exam?
Send note, sir.
Kailan ba exam?
Reviewer,
Next
sir.
week po.
Next week
Next
na?
week po ata, sir.
Next week na ba?
Yes, sir.
February 4.
Oh, sige,
Hello,
sige.
guys.
Send ko na.
Presal. Presal.
Sige na. Sige na, sige na.
Bye, sir.
Bye.
Reviewer, sir.
Thank you, sir.
Goodbye, sir. Thank you, sir.
Yes. I'll be sending this reviewer to your group chat.
Thank you po.
Sir, lahat
Thank you, sir.
from the beginning.
Waiting, sir. Waiting.